Thank you guys. Thank you all for tuning in this morning for North San Diego County Realtors Legal Update. This will be recorded, but it will not be available for a couple weeks. Gov has been providing our association with legal update training since 2013, and it is always a pleasure having him share his expertise and knowledge with our members. As some of you may know, today's legal update was originally scheduled as a live class, which many of you know, I know we're looking forward to. I know I was, but unfortunately, CAR is not allowing our instructors to travel at this time, as their main priority is keeping their instructors and our members safe. And of course, we did not want you to miss out on all the new laws and regulations for 2022, and also updates on the RPA as well as other forms. So here we are, we're on Zoom again. Although Gov Hutchinson does not need an introduction, I will give one just in case there are some new members that have not had the opportunity to attend one of his presentations, but be prepared to receive a great deal of valuable information that will help you in your real estate business, as well as reduce risks in your transactions. Gov Hutchinson is Assistant General Counsel of the California Association of Realtors. Gov has been with CAR since 1985 and manages CAR's Member Legal Services Program in Los Angeles. Gov advises realtors through the hotline on all aspects of real estate law, and he trains and supervises other hotline attorneys. Gov received his bachelor's degree in history at Princeton University and his Juris Doctorate from University of Pennsylvania. He has written for California Real Estate Magazine, co-authored CAR continuing education courses, and is a master instructor for the education division of CAR with certifications from the Department of Real Estate, affiliated trade associations, city and county bar associations, and major real estate firms. And now, Gov, thank you so much for being here. The floor is yours.
All right, thank you. Good to be here virtually. I also was looking forward to visiting you live. You were going to be, I think, the first live visit I was going to have in a couple of years. But as Lisa pointed out, that's been postponed a little bit. But I am expecting to be able to come out to see you guys in person later this year. I'm pretty sure I'll be able to do that. So until then, we are doing this virtually, but I think I think we can make it work. If you have any questions, first of all, I just put in the chat my email address in case I forgot to do it later. If you have any questions on anything I'm talking about today, you can put them in chat during the presentation, but if something occurs to you later, feel free to email me. You can always email me. I always respond to all emails. Sometimes it takes a day or two, but I do respond, and I can answer all your questions, okay? So today's topic, I always come around this time of the year, is basically what we call legal update. I'm going to tell you all the new stuff, and that mainly means new laws, but I'll also talk about forms a little bit as well, okay? Everything tends to start right at this time. The forms get updated mid-December, and all the laws take effect January 1st, typically, although you'll see some of them aren't. So this is a good time to have a meeting like this, early February, to let you know what's going on. Let me start with, get out of the way, sort of a couple of topics that I've been talking about nonstop for 2 years. Just give you the latest information on that. And one of them is COVID, and one of them is evictions, because those we just got so many questions on. Starting with COVID, the good news, of course, is that most of the regulations related to COVID that affected you in real estate are long gone, and they're not coming back. All those PED forms, you've probably forgotten those already, but you know, we had all sorts of protocols and rules and social distancing and sign-up sheets. That's all gone. The only thing left, though, is the mask wearing rules. And until we're almost at the end of that, maybe. I mean, here we are, February 4th, right, or 3rd. February 15th is when the mask wearing rule is scheduled to end, at least in California. I mean, I'm in LA. LA has its own rules. I don't know if San Diego County or your area has its own rules. But the state rules are that you have to wear a mask when you are in indoor public settings. And for real estate agents, that's defined as showings and open houses. But, you know, that's scheduled to end on the February 15th. However, number one, local jurisdictions can extend that if they want to. And number two, remember the owner of the house, it's their house. And if they want their own rules in their house, they're entitled to it. They can say beyond February 15th, I want everyone wearing a mask if you want to come in my house. I mean, homeowners can even be stricter than that. They can say, you can't come in my house unless you can prove you're vaccinated or something like that. I mean, just because that's not what the government requires doesn't mean that's not what the homeowner can require. It's their house. They can have pretty much, you know, pretty rules, and they can't discriminate, obviously, but it's not considered discrimination to require people to wear masks or be vaccinated or something like that. Okay, but the state law expires February 15th. But then there's a whole nother set of rules regarding offices. So there's the California Department of Public Health that deals with the mask wearing, like I just talked about. But then all of us working, I mean, a lot of us, I've been working from home for a long time, but eventually I'll be back in the office. But you guys have real estate offices. And what are the rules there? Well, that's Cal OSHA. And Cal OSHA says still, if you work in an office, you should wear a mask, unless you're alone in the room or you're eating or drinking. Some people, though, are exempt from wearing a mask for health reasons or religious reasons. But if those people, if you're in an office, you have to wear, you have to social distance and either be fully vaccinated or take a COVID test every week. If you're vaccinated, I mean, if you're going to wear a mask, though, you don't have to worry about social distancing. You don't have to worry about being vaccinated. You just wear a mask. Okay. Now, you may have heard that there was going to be a federal mask vaccination mandate, but that did not happen. It's probably never going to happen. So, in other words, there's no law that requires you to be vaccinated in order to work in an office. But once again, just like homeowners can have their own rules because it's their home, a business owner, an office owner, not just in the real estate industry, in any industry, can have your own rules, and they can be stricter than what's required by the state. So if an office wanted to have a rule that you can't come to work unless you're fully vaccinated, regardless of whether you're wearing a mask or not, which happens to be the rule for where I work at CAR, then the company can do that. But other than the company doing it, the state simply, there's no vaccination mandate, there's the mask wearing mandate. Okay, how long is this going to last? We don't know. I mean, I know the wearing the mask for the showings and open houses, that's scheduled to end February 15th. The wearing the mask in the office, unless you are alone or eating or drinking or have an exemption, that's for now going on indefinitely, but I'm sure it's not going to go on forever. Okay. The last thing is there's still the rules in place where you're in an office and someone who works in the office all of a sudden tests positive for COVID. The office owner in real estate would be the broker, has to tell everyone who's been working in the office that you might have been in contact with someone who's now tested positive. You don't have to tell them who it is who tested positive, but you got to say, you were in the office with someone who's now tested positive. You got to tell them within a day. And the person who was sick, who got tested positive, can't come back to work for at least 10 days and until no fever and symptoms are gone. What about other people in the office with the person who tested positive? For anyone who's vaccinated, they can continue to come to work, but they should social distance for 2 weeks. If someone who's been in the office, close contact with the person who's now tested positive, and this person is not vaccinated, that person should also stay away from work for 10 days. And also social distance when they do come back to work for a total of 14 days. So that's the latest on that. Hasn't changed much recently. All right, the next big topic we've been talking about forever is landlord tenant and evictions. We're pretty much at the end of the road here for that, thankfully. You remember for a long time, you couldn't evict someone for non-payment of rent if they had a COVID reason, and that expired back in September. But did you know, and I know this very well being in Los Angeles, come April 1st, so everywhere in the state right now, the state law supersedes the local law, and you absolutely have the right to evict a tenant for non-payment of rent, whether they have a COVID reason or not. The one catch that lasts until the end of March is, if you want to evict a tenant right now for non-payment of rent, you have to apply for rental assistance first. There's a website called housingiskey.com. So if I'm a landlord, I got a tenant not paying rent. Whether they say it doesn't matter whether they say it's COVID or not, it doesn't matter. I can evict them, but I can't evict them until I first apply for rental assistance. So I got to go to housingiskey.com, look up my city or county. That'll tell me the form I need to fill out to apply for rental assistance. Rental assistance means applying for free money from the government. I mean, you paid your taxes, it's money coming back to compensate you for unpaid rent. And the tenant has to fill out their own form to apply for this. So let's say I'm a landlord, I go through the process. If the tenant doesn't cooperate within 20 days, I can go ahead with the unlawful detainer. If the tenant does cooperate by filling out their form, then I have to wait until I get a response from the government, whether I'm entitled, whether I'm going to get the money or not. So that is still a delay on evictions right now. This all ends at the end of March. Starting end of March, you don't have to apply for rental assistance in order to evict for non-payment of rent. And if you're already in the process, you've already been applying for rental assistance and you haven't heard back yet, by the end of March, you can, at that point, you don't have to wait anymore. You can go ahead and do your eviction. The other thing is that lasts until March. Let's say a tenant owes me back rent. Can I sue for the back rent? Absolutely. But you first have to apply for rental assistance. So until the end of March, in order either to sue a tenant for back rent or evict a tenant for non-payment of rent, you first have to apply for rental assistance. Now, what if the tenant is doing something else wrong? They have subtenants they shouldn't have, they're damaging the property, criminal activity, they have pets they're not supposed to have, subtenants are not supposed to have. You can evict them for them right now. You don't have to apply for rental assistance. Well, what if they're a month-to-month tenant and I just want to evict them? I have no particular reason, but they're a month-to-month tenant. Can I just give them 60-day notice to leave? And the answer is yes, unless you're in a rent control city or your rental property is not a single family house, it's not a duplex, and it's more than 15 years old, in which case we're back to that California rent control, which was in effect before COVID, which if you're in an older building, there are only certain reasons you can evict a tenant. You need just cause. But anyway, the big thing to know is end of March, this goes away. We're back to where we were. You're basically back to the way you were pre-COVID as far as tenants are concerned, unless you live in a place like I do, Los Angeles, which has already announced that effective April 1st, when the state law expires in LA County, they're going to put it back to the way it was. You can't evict a tenant for non-payment of rent if they have a COVID reason. So LA is bringing back the statewide eviction moratorium that was terminated last September. And I'm just telling you this, just be aware that your local jurisdiction could do something like that if they wanted to. You would know better than I do if this is happening where you are. If it's not happening where you are, we're pretty much back to normal April 1st, okay? That's the latest on that issue. Another issue is people keep asking me, to answer your question, Lisa, how long is a reasonable time to wait? There is no reasonable time right now. Right now, you got to wait. But the good news is you don't have to wait after March 31st. Unless that state law gets extended, which I doubt, your waiting is over end of March. In other words, if the city or county is real slow making a decision on the rental assistance, you don't have to wait. Right now, you got to wait till they make a decision. But that'll end March 31st. The last thing to mention is raising rent. Can I increase the rent on my tenant right now? And there are three situations. If you're in a rent control city, you can only increase the rent as much as the rent control as the city allows you. I mean, LA has rent control, Santa Monica has rent control. And if you're in those cities, if your property comes under the city rent control ordinance, that's your limit. What if I'm not in a rent control city, or my property is in that city, but it doesn't come under the local rent control ordinance? Well, then we have, like I just said, the California rent control law, which says if your building is more than 15 years old, you come under California rent control, which means you can only increase your rent by 5% plus inflation. In San Diego County this year, the inflation rate is 4.1, which means I can increase my rent on the tenant by 5 plus 4.1 or 9.1. That number is going to change in August. Since we have inflation this year, 5% plus inflation, the inflation is like 7%. But there's an overall cap of 10%. So if your property comes under California rent control, right now you can increase their rent in San Diego County by 9.1%. Starting in August, you'll be able to increase the rent by 10%, but never will you be able to increase it more than 10% in any given 12-month period. But then the third thing, let's say I got a single family home. I'm not under rent control, right? Right. Does that mean in my single family home, I can increase the rent by as much as I want? There's one more thing you got to think about. If where your property is, you're under a state of emergency. And remember, there were all these, over the last couple of years, many wildfires in California, which triggered states of emergency being imposed. And many of these states of emergency are still in existence. How do I know if my property's in an area that's under a state of emergency? There's a website. There's a state office called the OES, the Office of Emergency Services. You go to their website, you can figure out if there's a state of emergency where you are. If there is, California's anti-rent gouging law says you can't increase the rent by more than 10% since the beginning of the state of emergency. So what if I got a single family home not in a state of emergency? Then you can increase the rent however much you want. Okay? Complicated stuff. Don't be the expert for your client when your client says, I got this tenant, how much can I increase the rent and can I evict them and what form do I got to? By the way, there's a special 3-day notice form you got to use till the end of the March before you want to evict. I mean, if you want to call the legal hotline, which I'll put that number in the chat, we can walk you through it as a landlord to tell you exactly how much you can increase the rent and what type of notice do you have to give. But it's complicated. Don't just casually tell your clients what they can do and not do, unless you're actually getting paid to be a property manager, in which case they expect that from you. So in that case, call the legal hotline, the number I just gave you, and we can help you, okay? John Rice, yes. Single family homes are not under California rent control. So unless you have a local ordinance, you can definitely evict a tenant now to sell the, to fix up the house in order to sell it. If you were in Los Angeles County, the answer is no. In LA County, the only no-fault evictions they allow are criminal activity, damaging the property, or owner move-in. So in LA County, sellers got a single-family house and they got a tenant in there and they want to kick out the tenant so they can sell the house. Can't do it. They got to wait till they sell the house, and then the buyer can kick out the tenant based on an owner move-in. But if you're not in LA County, yes, absolutely, you can give them a 60-day notice if they've been there more than a year, 30 days less, and you can kick them out now. You don't need a reason, in other words. For single-family homes, you can just do a no-fault eviction, okay? One more thing to mention, or a couple more things to mention. When I say properties under California rent control, you can't evict unless you have certain reasons, the tenant doesn't have those protections until they've been there at least a year. You know what some landlords are doing now? Even though they got an older building, they're signing up their tenants for 11-month leases, which gives them the flexibility after 11 months. If they don't like the tenant, they can kick them out. They don't need just cause until the tenant has been there 12 months. But if you got a rental property that's more than 15 years old, once the tenant's been there a year, you can't just evict them for any reason at all. Okay? Single family homes are exempt from that. You can do that. All right. Maria Lopez says you call the hotline. No, we deal with state and federal law. Generally, we don't keep up with local laws, but when it comes to evictions, we can help you, okay? In general, that's a good point. We do not know the local laws of every city in California, but when it comes to just evictions, we can help you with that. All right, let's now talk about new laws. Got those out of the way. First, let me talk about some new laws that are going to affect realtors directly. Number one, it's a month old now, but there's a new requirement. If you're staying with rentals, if you have a new tenant, you got to give them this new mold booklet. Yes, mold. So there's a booklet that came out. It's available to you as a realtor for free on zip forms on the library called Electronic Publications. It's called Information on Dampness and Mold for Tenants in California. This does not apply to your existing tenants. Any tenant you had in existence on January 1st, you don't have to do anything. But if you get a new tenant starting January 1st, a month ago, you have to give this residential tenant this new mold information booklet. By the way, if you use the CAR rental agreement, the LR form, it's pre-attached to the rental agreement. It's automatic. If you do a rental agreement that's not the CAR form, you need to go into that zip form library I just said, EPUBs, Electronic Publications, and get that and email it to your tenant, okay? But that's a requirement for new tenants, not existing tenants, that took effect January 1st. Now, another new law that affects realtors directly, there's another new form, disclosure form coming out. Right now, you know, for years and years, if somebody asked me, what are the mandatory disclosure forms when I'm selling a house? For a long time, I said there are 4 of them, right? The NHD report, number 1, the TDS, transfer disclosure, number 2, the seller property questionnaire, number 3, and the lead paint form, number 4. And of course, if you were exempt from a TDS because it was a probate, REO, bankruptcy, trust sale, then, that means you're exempt from the SBQ, so you did this other form called the exempt seller disclosure, ESD. But there were big 4 disclosures. Then remember last year we added a 5th one, the fire hardening and defensible space form that's required if you have a listing in a very high or high fire hazard zone. Well, guess what? On July 1st, we're going to have a 6th disclosure form. What's it called? It's called the Appraisal Discrimination Notice. What does this form do? It tells your client that if they got an appraisal and they think the appraisal was artificially low and they think it was based on discrimination, you know, have you ever heard about these sting operations where some appraisers have been caught appraising the same property at different values depending on who lives there? Obviously, that shouldn't be the case. Anyway, the point is there's this new mandatory form July 1st that you have to give to your buyers. It's basically telling them, you have to give it to the buyer and the seller. You're basically telling them, if you think the appraisal you just got was discriminatory, here's where to file a complaint. Well, we're going to make this so easy for you because we're going to pre-attach this form to the purchase contract. You're not going to think about it. If you use this purchase contract, you've done your job. I mean, the other disclosure forms are not attached to the TDS, NHD, lead paint, SBQ, and the fire hardening. Those are not attached to the TDS, to the purchase contract. You have to come up with those yourself. But this new disclosure form, the appraisal discrimination notice, you're not going to have to do anything. It's pre-attached to the purchase contract. You know how right now there are 6 forms attached to the RPA? The agency disclosure, the dual agency form, the wire fraud advisory, the buyer inspection advisory, the fair housing advisory, and the California privacy notice. So right now there are 6. In July, there's going to be a 7th attached form to the TDS. By the way, of all those forms I just mentioned, the 6 that are currently attached, do you know there's only 2 of those that are actually required by law? And that's the agency disclosure form and the privacy notice. The other ones are good, not required by law. Well, this new one, the 7th one, the eviction discrimination notice, is required by law. So it's pre-attached to the purchase contract. Don't unattach it, right? It's a required form you must give to your buyer and seller. That's why we attach it to the purchase contract, because it goes to, it's a disclosure you have to give to the seller and the buyer. And it's going to be an attachment that they're both going to sign, and you're done. Okay? All right. Other laws that affect realtors directly. There's going to be another July 1st law, which won't affect you nearly as much as the one I just mentioned. Do you know that, by the way, you know how many laws the governor signed this year? 836. How many of those laws related to real estate? Only about 30. And we have a handout on our website if you ever want to look at it. It's called 2022 New Laws. Of these 30 new laws, most of them deal with either housing discrimination or building houses. And I'll mention a couple of them, but most of them don't affect your daily life. I've already mentioned one that affects your daily life. That's the eviction discrimination notice. Another one that affects your daily life is the mold booklet you have to give to tenants. A third one also relates to discrimination. You know what a deed restriction is? You have a deed that's recorded, and there's an attachment to the deed that says something like, this house can only be sold to people whose income is less than whatever. It's called an affordable housing deed restriction. Or sometimes there's a deed restriction that says something like, this property can't be used to sell intoxicating liquors. You can't open a bar on this property. And those are legal. But then there are also deed restrictions that are not legal. You'll still come across some of them that say something like, you can't sell this house to anyone who's not a Caucasian. Now, you know perfectly well that's not legal. So what's the big deal? It's there, but it's not legal. I can ignore it, right? Of course you can ignore it. But some people get offended by that it even exists. So they own this house, and there's a deed restriction attached to their deed that offends them. I think it would offend me too. So not only is it not enforceable, you want it removed. You want that deed restriction physically removed from your deed. Or maybe you live in HOA and there's CC&Rs, and they're old CC&Rs. And there's a covenant in the CC&R that says you can't sell this house to people who aren't Caucasian. Once again, not enforceable, but some people don't want it there anyway. Well, now there's a new law that says you have the right to go to the recorder's office in your county, if you have one of these, and the recorder's office has to, for no charge, has to basically remove, redact, eliminate that unlawful deed restriction or unlawful CC&R within 3 months. That sounds good. Plus, every county recorder's office in California, in every county, has to set up their own program where they're going to painstakingly go through every deed recorded in that county. And if they come across any unlawful deed restrictions, they're going to remove them. Of course, that's going to take a long time. But if you go directly to the recorder's office, you can get it done in 3 months. And it doesn't even have to be the owner of the property. Anyone under the owner can say, hey, can you do this for me? And it doesn't even have to be the actual owner who does this. How does any of this affect realtors? Well, there's one more part of this law that says, effective July 1st, if you're either listing or selling a house and you the realtor happen to be aware that there's an unlawful deed restriction, you have to communicate that fact to your client and also tell your client, hey, did you know there's a streamlined free process now? You can go to your county and get it removed. What triggers this is you being aware of this deed restriction. You know something, I think the average realtor, you're not going to be aware. The only way you'd be able to know this would be you'd have to read the deed, you'd have to read the CC&Rs, or sometimes it's attached to the prelim. But you are not required as a realtor to read the prelim or the deed or the CC&Rs. But maybe you do. Maybe if though, for some reason you do happen to know on the house you're either listing or selling that there is one of these racial or religious discrimination covenants, you have to tell your client. Well, is there a form for me to use to tell my client? Actually, we did come up with one. It's not a form on zip form. We have this library on CAR called Sample Legal Letters. And we just added one. This is the letter that you could use to communicate to your client, hey, there's a deed restriction against your property that's not legal, and you can go to the county recorder's office and get it removed. So we've got a document, you don't have to use it, but maybe this will never happen to you. Maybe never once will you actually have this knowledge. Someone's asking me, if the realtor comes across one, can you ask the title officer to remove it? Well, there's a process. I mean, when the title officer doesn't have to do it. The title officer can do it. Anyone can do it. Anyone can go to the county recorder's office and say, I'm here about 123 Elm Street in Escondido. And I'm here because I have learned that there's this deed restriction regarding 123 Elm Street, and I'd like it removed. So the realtor, you can ask, you can do it yourself. You can ask the title officer to go to the recorder's office. Nobody has to do it. But if somebody does go to the recorder's office has to do it within 3 months. Okay? All right. Any other laws that affect realtors directly? Another fair housing related one is that not this year, but 2023. If your real estate license comes up for renewal, not this year, but 2023 or later, as part of the continuing education, the classes you have to take to renew your license, there's a new class, a new 1-hour class regarding something called implicit bias, meaning all of us unconsciously, without even knowing it, we're biased in certain ways. You're going to take a class to help you identify any biases you have and how to address them. It's also going to expand the fair housing classes. So you'll notice that not this year, but next year. Okay. Any other laws that affect realtors directly? Couple more. One of them is good news for all of you, and that is, let's say I have a real estate license, and then I get divorced or I get married, or for whatever reason, I change my last name. Well, obviously what that means is you have to update your license because your license has to be in your current legal name. But here's the good news. This new law says Even if you change your last name and get your new license in your new name, you can continue to market yourself under your former last name. In other words, it used to be until this year on your for sale signs or everything, you had to use the name that was on your current license. Now, maybe you're known in the community under your previous name. You can continue to use that, even though the name on your current license is different. You can use either name. You can use both names. You can take turns, whatever you want to do. So that's sort of more flexibility for realtors. And then the last thing, as far as laws that affect you directly, and then I'm going to talk about SB9, which you all probably want to hear about. The last new law that affects realtors really directly is getting back to this, the fire hardening defensible space law. Remember, you only have to give that form to the buyer if it's a TDS transaction, meaning it's not a probate, it's not an REO, it's not a bankruptcy sale, it's not a trust sale. It's a sale where a TDS is required and the property is in a high or very high fire zone, fire hazard zone. So I take a listing. How do I know if my listing is in a high or very high fire zone? Remember, there's 4 possibilities. Your listing is not in a fire zone, it's in a moderate fire zone, it's in a high zone, or it's in a very high zone. The form is only required. Yes, Sandy, CARCE will definitely be updated. How do I know that my listing is in a very high or a high? Because if it's in a moderate fire zone or it's not in a fire zone, I don't have to use this form. How do I know, though, when I take a listing, which zone I'm in? Well, you could look at the CAL FIRE maps, but you don't have to do that. You can just look at your NHD report. Remember, your NHD report has 2 fire zones. One of them says very high fire zone. The other one says wildland fire area. If neither box is checked, your listing is not in a fire zone, you don't need this fire hardening form. If the very high fire zone box is checked, obviously you're in a very high fire zone. Obviously the form is checked. The form is required. But what if the very high fire zone box is not checked, but the wildland fire box is checked? Yes, Kathy, I'm going to talk about the new RPA pretty soon. Once I finish the new laws, which will be soon. So you got a listing, the wildland fire box is checked. What does that mean? That means you're in a state fire responsibility area and you're either in a moderate or a high fire zone. Well, I know this FHDS form is only required if I'm in a high, but the fact that I'm in wildland means I'm either in a high or moderate. Which one is it? That's when you go to your NHD provider and say, I noticed you checked the wildland fire box. Am I in a high or a moderate? They have that information, they can give it to you. You know what's going to change this year, though? Right now, every one of us, we either live in a state fire responsibility area or a local fire responsibility area. If you're in a state, CAL FIRE is responsible. If you're in a local, your local fire company is responsible. So all of us are either in a state or a local. And then if we're in a state area, we're either in a very high fire zone, moderate, or nothing. But if I'm in a local fire zone, did you know it's either very high fire zone or nothing? There's no such thing as a high fire zone or a local fire zone in a local fire responsibility area. That is going to change this year. CAL FIRE is now going to map all the local areas into high and moderate. So there are going to be a lot more properties that are probably going to be requiring this new FHDS form. And then the NHD report is going to have to be modified. So there's a new box telling you if you're in a high fire zone in a local fire area. Because right now the NHD only tells you you're in a very high or you're in a high or moderate in a state area. The NHD form right now doesn't talk about high fire zones in local areas. All I'm telling you is at some point this year, your NHD form is going to look different and they're going to be more fire zones. Okay. All right. That's the only thing those are all the laws that affect you directly. I want to talk about one other very important law that affects you indirectly, but being in the real estate industry, it's something you got to know about, and that's SB9. Remember I said there are a lot of new laws that try to make it easier to build housing? SB9 is the big one. SB9 says you own a house in an R1 single family zoning area. Before SB9, that means you can only have one house there. If you want to try to build another house, you'd have to get a variance. You'd have to have a hearing, environmental impact report, and the city or county could simply say no. SB9 says if you're eligible, you can build a second unit on your property and the city or county can't stop you as long as you jump through certain hoops. But if you jump through these certain hoops, there's no hearing, there's no environmental impact report, you can just do it. What are the hoops I have to jump through? Well, first of all, you can only do this if you're in what's called an urban area or urbanized area. And a lot of you guys in North San Diego, you're probably not in what's considered an urbanized area. Well, how do I know if my house is considered being in an urbanized area or not? This is determined by the US Census Bureau. You have to actually Google US Census, go on their website, you can figure out if your house is in an urbanized area or not. If you're not, you can't take advantage of SB9. But let's say you are in an urban area. Can I build another unit? Well, now you have to, more questions. You can't do it if you're in farmland. You can't do it if you're in a conservation area. You can't do it in protected habitat. You can't do it if you're in a historic or landmark district. And a lot of cities, believe me, recently have been expanding their historic and landmark districts so that property owners can't do this. You can't do it if you're in a very high fire zone, unless you've upgraded the property with the dual pane windows, etc. You can't do it if you're in a earthquake fault zone, unless you've upgraded the property with the anchor bolting, etc. You can't do it if your property's in a 100-year flood zone, unless you've taken the mitigation steps recommended by FEMA. But let's say you're not into any of those things. You're urbanized area, you're not in farmland, you're not in these other areas. Well, now, the only hoop you have to jump through now is if you want to build another unit on your property, it has to meet buildings, the building code, health and safety rules, the general plan, and objective design standards put in by the city or county. The city or county can say, well, if you want to use SB9 to build another property, then you have to look a certain way. It's got to have like a setback of this and blah, blah, blah. Now, they can't be too strict. So there's going to be litigation coming because some cities are going to say, well, if you want to build another unit, it's got to be this, this, and this. And they're basically going to make it so strict, it's almost impossible to build. And they're not going to get away with that. But cities are going to be able to get away with so-called objective, reasonable design standards like setbacks, etc. So, assuming you meet all those criteria, you're entitled to ministerial approval. In other words, you're automatically approved if you meet these requirements. There's no discretion on the part of a local government to not allow you to do it, okay? Also, not only can you do that, but you can also do a lot split. You can split your lot to create two lots and actually have two houses on each one. You can only do the lot split if each lot is basically the same size. The total, each lot has to be at least 1,200 square feet. So you can only do it if the original lot was at least 2,400 square feet. You can only do this if the owner of the property doesn't own either property on the other side and has done a lot split there. You can't do it if the property we're talking about was itself created by a previous lot split. And here's the real important thing. You can't do the lot split unless the owner of the lot commits that they will live in the property for the next 3 years in one of the units. Okay. Plus, there's going to be issue with the lender, of course. I mean, if the lender has a lien against the whole property, and if you then want to do a lot split and build another house, you're going to have to get a construction loan, perhaps. And is the original lender going to be willing to subordinate to that? Who knows? And anyway, there's a lot of obstacles. But the point is, it's easier now than it was before to turn your single family lot into 2 units, 3 units, or 4 units. One more important thing though, if you live in an HOA and you already have CC&Rs that say no second units, no lot splits, then you can't do it. The CC&Rs are going to supersede this. Similarly, if your property is on the coast and it's under the jurisdiction of the Coastal Commission, that also takes precedence. So just because under SB9 you might be able to build another property, that doesn't mean you can build it if the Coastal Commission doesn't approve it. Okay. All right. Okay. So that's a big issue. If you have questions on this, call the legal hotline. We can help you with this. By the way, sounds like a revolutionary change, right? Wow, I can turn single family into 4. Did you know that even before SB9, it wasn't too hard to turn single family into 3? Because there was a law passed a couple of years ago that makes it a lot easier to do an accessory dwelling unit. Let's say I got a house. Forget SB9. I got a garage. I want to convert my garage to another unit. I can do that now. I don't need city approval as long as I meet the building code. Or let's say I want to add a separate unit, a detached in-law unit, or accessory dwelling unit, granny flat, whatever you want to call it. If it's no bigger than 800 square feet, 16 feet high, 4-foot setback, I can do it. City can't stop me. And you know what else? The HOA can't even stop me. So property owner, but you can't do both. You can't build a new unit under SB9 and then add accessory dwelling units for that. You see what I'm saying? So if I'm a property owner in a single family lot and I want to see if I can increase, I want to add a unit or 2, I can either go the ADU route, in which case there may be a size limitation, but the HOA can't stop me. And by the way, I can do a short-term rental. I didn't tell you this. If you build a new unit under SB9, you cannot have short-term rentals on that property forever, which is 30 days or less. So, and the advantage of ADUs, you have some advantage. The advantage of SB9 is you can actually, those are legal units you can actually sell separately. So bottom line, stuff to think about, but that's sort of an important change to the law. Elena, what about HOA fees? Remember, the HOA doesn't have to allow this at all. So the HOA can have whatever sort of rules they want, because they can just say no to the whole thing. You don't have an absolute right to do this. If you're talking about accessory dwelling units, yes, they have to allow those, and then they can have reasonable fees associated with that. Okay. All right. Before I turn to the contract, I think I got one more question I didn't get to, and that is, it just came to me. My office told me I need to fill out the form even though the homeowner is not in a high or very high fire zone. That's a good point. So this form I was mentioning, the fire hazard defensible space form, I said it's required if you're in a high or very high fire zone. But it says right on the form, you can actually provide this form even if you're not in a high or very high fire zone. If the seller thinks it's a good idea, I think this is a good form. I want to give it to all my buyers because everybody wants to know about fire risks and things like that. You can do it. Now, the person's asking me saying that my office told me I need to do it. Now, if your office is saying that's office policy, well, I don't think the office should be setting policy for your clients. But if your office is if your office has a policy that we're always going to try to convince our sellers when we have a listing to provide the fire hardening form, even though it's not required because we're not in a high or very high fire zone, that's a different thing. But if your office is actually telling you that it's required to give the fire hardening defensible space form, even though it's not in a very high or high fire zone, that's not true. But maybe that's just a company policy. You're going to try to convince your sellers that, because remember, it's ultimately the seller's decision to provide a disclosure form. I mean, it's a statutory form. I mean, if the real estate office, if you as a broker come up with your own disclosure form that you think it's a good form, yeah, you can give it to the other side if you want to. But this is a sort of a legal form. It's ultimately the seller's decision if they want to provide this form, even though it's not required. You see what I'm saying? Okay. By the way, one other law I want to mention. Gail's asking me, Gail, maybe you can expand your question. What about fire inspections required? Fire inspections are never required unless you're in a, maybe you're talking about defensible space inspections. Those are only required if your city or county has an ordinance requiring them. I will tell you right now, there's nowhere in Southern California where these inspections are required as a condition of selling the property. I know, like in Big Bear, for example, they have inspections every 6 months, whether you're selling or not. But nowhere in Southern California, just because you're selling the house, do you have to do a defensible space inspection. And don't let any local fire company try to tell you otherwise. Some of them are confused by this law. If I want to sell my house, even if I'm in a very high or high fire zone, I do not need to do a defensible space inspection. Of course, however, CAL FIRE or the local fire company can randomly audit my house anytime they want. And if they come out to my house and they see I don't have 100 feet of defensible space, they can tell me, we're coming back in 3 months. If you haven't cut down the trees and fixed everything, we're going to find you. But that could happen whether you're selling or not. The point is, this form, all this form says, it's basically saying to the buyer, when you buy the house within a year after this purchase, you do have to do a fire inspection. So Gail, if that's what you're asking, yes. If you're selling a house in a high or very high, the buyer after close has a year to go get a defensible space inspection. And your last question is, well, can in escrow the buyer request that the seller do a defensible space inspection? They can request it and the seller can say no. You know what I'm saying? Seller probably doesn't want to do it because if they do it, they're going to find out now they got to cut down a tree or something, and they'd rather dump that problem on the buyer. So it's a negotiable item. Okay. All right. Let us shift gears and talk about form changes. Okay. Those are really much all the laws you really need to know about that affect your life. What about form changes? Well, obviously the big news in forms is the purchase contract. The purchase contract changed on December 14th. And I'm actually going to share my screen and actually pull it up, okay? So we can all look at what I'm talking about. Okay. So the form, as you know, it went from 10 pages to 16 pages. And your first reaction to that is going to be, wow, they must have changed a lot of stuff. And you know something? Yes and no. The structure of the form is pretty much the same. All the paragraphs you're already familiar with are pretty much still there. Well, how did it go from 10 pages to 16 pages? What the Forms Committee did, they just added a lot of explanatory language to try to deal with issues that keep coming up in escrows. Give you an example. You know the buyer, when they do an inspection, do they have to give a copy to the seller of the inspection? Yes. Does that include an appraisal? Does the buyer have to give a copy of the appraisal to the seller? The answer to that is no. It's always been no. But now we actually put that in the contract. We actually say in the contract you do not have to give the appraisal to the seller unless it's an FHA or VA buyer. So there's just a whole lot of stuff like that, that these are questions that keep coming up, and there's always been an answer. So if you ask the CAR lawyer, we'd tell you. But now we decided to let's put it in the contract. So you don't have to actually ask anybody, ask a lawyer. We just cover the issue in the contract itself. So anyway, I'm going to go through this for a few minutes and just give you the big picture on this, okay? I'm just going to point out some of the big changes, okay? By the way, not only did this form change, but all the forms that go with the form, like the notice to perform and the contingency removal, they all changed too, but they only changed slightly just to make them consistent. There's only one brand new form, which I'll mention in a second. But first of all, in addition to the fact that there's all this new explanatory language, the other change, of course, is paragraph 3. Paragraph 3 is a new concept. Everything in paragraph 3 is already in the old contract. But what's different about paragraph 3 is it puts all in one place all of the deal points. Okay, when a buyer and seller are negotiating a contract, what are the things they negotiate on? How much am I paying? How much is the deposit? How long is the escrow? How long do I have to remove contingency? In other words, how much, who's paying, and what's the deadline? Those are the things you negotiate on. And in the previous contract, those blanks were spread out through the first 13 paragraphs. Actually, the first 16 paragraphs. Now, all of the deal points are in one place. Paragraph 3, the grid. So other than paragraph 3, you're not going to be negotiating anything. Everything you negotiate is right there. And all of your deadlines are right there. And I love how it's set up. It's just logical. First, we have the price. Then we have close of escrow. Then how long is the offer good for? How much is the deposit? What type of loan am I getting? Am I going to live there? And I'll go through a couple more things too. So it starts off with all the buyer stuff, and then it does the seller stuff. Purchase price, that's pretty clear. Have you noticed the all cash now is right next to that? It used to be the purchase price was in paragraph 1 and the all cash was in paragraph 3. Now it's all together. Makes sense. The first thing you're going to tell the seller is whether you're paying cash or not. The next thing you're going to tell them is when you're going to close. Remember, it says the word days, which means you count every day, but if the closing day is a weekend or a holiday, you close on the next business day. Then the expiration of offer, how long is an offer good for? 3 calendar days. Calendar days means you count every day, but the last day can also be a weekend. And then opening escrow is business days. So if your offer gets accepted today, today is day 0, tomorrow, Friday, is day 1. Saturday and Sunday are not business days. The second business day is Monday. The third business day is Tuesday, so you open escrow on Tuesday. And now look what it says. It doesn't say that deposits, you used to have a choice. You could have a deposit in the form of a check. Not anymore. All deposits are wire transfer unless you write it in. So there's, it follows logically, all the things you negotiate. You know what I really like? These 3 deadlines are all together. So if you're a cash buyer, you have a deadline to provide proof of funds. If you're a loan buyer, you have a deadline to provide proof of funds for the down payment and pre-qualification, pre-approval. Did you notice on the old form, these 3 things were spread out? I think it's great. It makes sense. They're all together. Your buyer deadlines, proof of funds and pre-qualification is all together. And look at this. You have now in the contract, in the old contract, you just said you had 3 days to either pre-qualify or pre-approve. And the answer is, which one is it? Well, now you're going to tell the seller whether the letter you're giving them is a pre-qual letter or pre-approval letter, or maybe it's an actual loan approval. The walkthrough. in the old form, you didn't find out until paragraph 16, how long do I have to do a walkthrough? Now you find out right away. Here's a new thing. Can a buyer assign their interest to another buyer in the middle of escrow? Yes, with the seller's permission, but the seller has to be reasonable. Well, look, for the first time, there's a deadline. If you want to assign your interest, you have to ask for it within 17 days. Otherwise, the answer is no. Seller doesn't have to be reasonable. What if you're going to, you're going to need a cosigner to qualify? And that's not going to happen till the end of the deal. You're going to change the 17 to 45. Here's my favorite change in the new contract. All 8 buyer contingencies are in the same place. For 30 years, I've been telling realtors that you have 8 contingencies and they're spread out all over the contract. They're all together. If you ever forget what the 8 buyer contingencies are, there they are. And you have the same deadline to remove them. You can change these numbers, of course, but they all start the same. What if I want to write a non-contingent offer? Like, I can remove the loan contingency right here. I can remove the appraisal contingency right here. If I want to remove any of these contingencies, I have to attach a contingency removal form. And remember the last optional contingency, if you make your offer contingent on selling your house first, you never have to remove that contingency. That contingency lasts until the day your house is scheduled to close, which you have disclosed to the seller on this attachment form. So this really lays out the 8 contingencies very nicely. And these are all the buyer deadlines, right? These are all buyer stuff. How much you're offering? When do you want to close? How long is your offer good for? How long do you have to get your deposit in there? What's your deadline to put in your pre-approval? What's your deadline for the walkthrough? What's your deadline to request an assignment? And what's your deadline to remove contingencies? Then we come to the seller deadlines. First seller deadline is moving out. When does the seller have to turn over possession to the buyer? Well, see, first it talks about what time of day. This is new, either upon the moment of recording or 6 o'clock. Well, that tells me what time, what day. The next line tells you what day. You're going to move out on the close of escrow day unless you check a box. But here's the only brand new addendum you have to deal with. Brand new form you're going to deal with a lot. Tenant occupied property addendum. What if I'm buying a house and there's a tenant already there? Is the tenant going to move out early? Is the tenant going to move out on the closing date? Is the tenant going to stay a few days after close? What's up with the tenant? On the old form, you dealt with the tenant in the contract on paragraph 9. On the new form, to deal with the tenant, you're going to need this addendum. So every time you write an offer on a property with a tenant there, you're going to need this addendum. You can create your own form if you want, but why not use the CAR form? And then we have the other seller deadlines. You ever want to tell your seller what deadlines do they have? It's M and N. They got a move out deadline. They got to make sure the buyer gets all the forms within 7 days. Buyer and seller both have to return escrow instructions within 5 days. Seller has 3 days to pay for the HOA docs. Here's a new one. Seller has 7 days to put in the smoke alarms and the carbon monoxide detectors. Do you know under the old form, your deadline to put those in was closing? Now the seller's deadline is 7 days. And here's another one. If the buyer or the seller is not a person, the buyer or seller is a thing, like a corporation or a partnership or a trust or an LLC, somebody is signing the form on behalf of the entity. But who's ever signing the form on behalf of the entity has to provide evidence to the other side that they are the right person to sign. If it's a corporation, they got to prove that they're the president. If it's a trust, they got to prove that they're the trustee. If it's a partnership, they got to prove they're the managing partner. And they have to provide this evidence within 3 days. So this is a buyer and seller deadline. And then I love this. These are all the things that buyers and sellers argue about at close of escrow. Where's the jacuzzi? Where's the tree that was there? Where's the electric car charging station? Where's the video doorbell? I thought that was part of the house. The seller says, that's not part of the house, that's mine. Well, now you're going to put in your offer. If you want the video doorbell, say so. If you want the spa or the above ground pool, say so. If you want the wine cooler, say so. If the seller doesn't want to give it to you, they'll counter you. But there should be no more arguments at close of escrow because something is there or not there. If there's any doubt in your mind, whether it's included or not, write it down. And if there's something in the house that you specifically don't want, maybe there's a chandelier in the dining room that you don't like, you want to put in your own chandelier. Now, a lighting fixture does come with the house unless you don't want it. So you have to say you don't want it. See what I'm saying? And then paragraph Q, this is just like paragraph 7. Who's paying for what? And there's a new option, both. If you check both, you're saying 50-50. Another new thing is, it used to have the HOA fees. You could negotiate who's going to pay for that. The Forms Committee said, let's just make it simple. Seller will pay for the HOA fee. We're not going to negotiate. Okay? All right. So you see that grid is really good. It has a lot of good stuff. Not new. You're familiar with all these stuff, but it's now all in the same place, which I think is good. So let me just spend a few minutes talking about other things. There's nothing new in paragraph 1, except, remember this used to say the real property. Now it says the property. Why did they take out the word real? Because we got rid of the mobile home purchase contract. So if you want to buy a mobile home, you use this contract plus the mobile home addendum. So in other words, we got this paragraph. It's just like in the old form where you talk about the addenda you're attaching. B, you're familiar with. C, you're familiar with. But this is new. These are new addenda. I already mentioned the tenant occupied addendum, which you're going to use every time you buy a house where there's a tenant on there. But we got rid of the mobile home purchase contract. So now you're going to use this form for the purchase, and then you're going to check this box for the manufactured home addenda. And we got rid of the probate purchase contract. So if you're buying a probate, you're going to use this form, and you're going to check the box and add the probate purchase agreement addendum. We've also got another new addendum. Some places in California now, you don't get a deed. You're buying an interest, a tenant in common interest is what you're buying. So you would use this addendum. And some places in California now, properties are owned by stock co-ops. So you're buying a share of a stock co-op, and we have a box for that too. So there are 5 new addenda, but the only one you're probably going to use a lot is this one. Because every time you buy a house with a tenant, you have to deal with the tenant. You know, you want to deal with them, whether it's a current tenant or going to remain. You have to put in the contract, when does the tenant have to leave? Okay, all right. Another thing I want to mention back in the agency paragraph, it now there's always an argument. The buyer's agent says to the other agent, I want you to give me the agency form that you gave to your client. Or the listing agent says to the buyer's agent, I want the agency form you gave to your client. Well, you don't have to do that. You only have to give the agency form to your own client. You don't need to see the other one. And now it says that. Just an example of more explanations. Okay. I'm just going to cover a few more highlights of important things that have changed. Okay. Once we get past this big paragraph 3 and the addenda, additional terms, or just a few interesting additional terms that weren't there in the old one. Here's a new one. Have you noticed this one in C3? This contract, buyer is giving permission to the seller and the listing agent to contact the buyer's lender directly. People have always asked us that question. Can the seller call the buyer's lender to check on the status of the buyer's loan? since we kept being asked that question, we put it in the form. Yes, buyer is authorizing the seller and the listing agent to contact the buyer's lender. Okay, so that's a new thing. Any other brand new stuff here? I like this one. Have you ever run into a situation where the seller closes, the buyer moves in, and the seller has left some of their junk behind? Are you allowed to get rid of that junk? Can you sell it? Can you keep it? Do you got to give it back to the seller? What are your rights? Now look at this. For the first time, it clearly says, all debris and personal property not included shall be removed. If items are not removed, such items are considered to be abandoned. So if you're the buyer and you move in and there's stuff left behind, all you got to do is send the seller a letter. You can email the listing agent, write the seller a letter. You only have to give them 3 days to come back and get it. After 3 days, you can do whatever you want. You can keep it, sell it, destroy it, trash it. And you can even sue the seller for the expense that it cost you to remove it. This is very much a pro-buyer change. The old form didn't really address this, so it defaulted to the law on rental properties. Do you know if you're a landlord and the tenant leaves stuff behind, you got to give them 17 days to come back and get it? And if it's valuable stuff worth more than $700, you got to keep it for them? That used to be applied to sales also, not anymore. 3 days, they got to come and get it. After that, it's yours. Do what you want. Okay? So that's an interesting one. Let's see, any other really interesting changes worth mentioning? I mean, I could spend 4 hours on this. There are a bunch of little things. There are a bunch of little changes, but they're not dramatically changing your life, right? Other than what I've told you already. There's another thing in here where we strongly advise your client to check out insurance. Insurance has become a big issue now. It used to be buyers just, close of escrow, they'd try to get, they'd get some property insurance. But insurance now is so expensive and sometimes hard to get that the form now tells your buyer, you need to think about insurability as early as possible. And you really shouldn't remove your investigation contingency until you've done that. Because if you remove your contingencies and then you find out how much insurance is, you can't say to the seller, well, now that I found out how much insurance is, I don't want to buy your house anymore. Well, you better figure that out before you remove your investigation contingency. If you can't obtain insurance, yes, then you can cancel based on that contingency. Okay, just a reminder to think about that. That's an important thing that you didn't think about too much before. Let's see. Like I said, a lot of little changes, but I'm not going to cover them right now. By the way, I've been talking to Shirley. I'm actually willing to come back to the association and do just an hour-and-a-half program for free just on this form. If you want that. Okay, so we'll see about that. Little things like, have you ever had a situation where the seller doesn't do the repairs on time, so the lender has to come out and reappraise it or something like that, and that costs money to the buyer? Well, now it says right in the contract, if there's any reinspection fee or anything like that, the seller has to pay for that. Any increased cost the seller has to incur based on lender requirements that were caused by the repairs not being done on time, that's a seller responsibility. All right, that's another example of just a little thing that was added to the contract. Another thing, what if, you know how the seller has to put in the smoke detectors and the buyer has to, within 7 days? What if you agree in the contract that it's the buyer's responsibility to pay for the new smoke detectors? How is that actually going to work? Well, now it explains it. if the buyer is going to pay, buyer shall deposit funds into escrow or directly to the vendor. In other words, the contract never addressed the issue of, well, if the buyer's paying, as a practical matter, how does that work? Paragraph 11 on the disclosures. The new thing, of course, is there's the new fire hardening and defensible space disclosure. I've already explained that to you. You understand that one anyway. Almost done here on things I want to talk about today. You know what's very important to remember that people don't always remember? When you give a disclosure to the buyer, they have to sign them and return them. So the seller has to deliver them in 7 days, but the buyer has to return them in 5 days. What if the buyer doesn't return them on time? The seller can cancel. This is a deadline. Every deadline in the form, if you miss it, the other side can cancel you. And that comes up a lot. So that's made a little bit clearer too. What else? What else do you really need to know? I like when we get, there's a new thing in paragraph 13. You know, you get insurance, title insurance when you buy a house, right? Right. Okay. Well, when I get title insurance, what type of title policy am I going to get? In the old form, it said you're going to get an Alta CA homeowner's policy. But what if not every property is eligible for that policy? So what if the property you're buying, because of the way it's shaped or whatever, is not entitled to that policy? What do you get? Well, in the old form, it says, if you're not eligible for that policy, talk to the title company and figure out what policy you want. Now look what it says. It says if that policy is not offered, your second choice is a standard CLTA. So now there's a first choice and a second choice. Under the old form, there was a first choice, and then you had to figure out the second choice on your own. Now, it's automatic. Of course, if the buyer wants to, they can get whatever policy they want. But the seller only has to pay for, if you're agreeing the seller's going to pay for it, they're going to either pay for this one or this one. If a buyer wants a more expensive policy, then the seller only has to pay for the cost of this policy and the buyer will pay for the excess. Okay, so that's explained here also. Paragraph 14, you're familiar with paragraph 14. It's just been reformatted a little. You know what I really like? You know, an issue comes up sometimes is I want to cancel the deal. Do I have whether you're the buyer or the seller, the question is, can I cancel the deal and get out of the deal? And now look at paragraph 14. It lays it out very nicely. 14C tells you exactly under what circumstances a seller can cancel. And paragraph D tells you exactly under what circumstances a buyer can cancel. If I'm a seller, what gives me the right to cancel? Number one, buyer doesn't remove their contingencies on time. I give them a notice to perform and they still don't do it in 2 days. Number two, if the buyer misses any of these deadlines, and there are a lot of buyer deadlines in the form. They're all discussed back in paragraph 3. And if the buyer doesn't do any of the things that they promised to do, pre-qualification, contact information about their lender, return the disclosures, deposit the funds, if the buyer doesn't do anything that they promised to do, the seller can cancel. And this is a list of everything the buyer is supposed to do. And then when can a buyer cancel? Well, maybe the seller put a contingency in their counteroffer. My counteroffer is my acceptance is contingent on finding a replacement property. Well, if they don't remove that contingency, you can cancel them. You can cancel if the seller doesn't do their contractual obligations back in paragraph 3. And of course, if you haven't removed your contingency, you can cancel. So paragraph 14 is not really new. It's just sort of formatted a little bit different, okay? The rest of the form hasn't changed much at all. The repairs are still the repairs. The walkthrough is still the walkthrough, prorations. All this is not changed. What's changed a couple of things is look at the MLS paragraph. It now tells the buyer that if there's any pictures of the property, videos, floor plans that are on the MLS, they're not going to be removed. The MLS is not allowed to remove them for 3 years. And once something is up there, it goes on the internet, they don't have the ability or the obligation to remove it. Because this comes up a lot. Buyers start demanding, well, now that I bought the house, I want all those pictures taken off. This sort of explains that that's not happening. Assignments. This is a lot bigger than the previous assignment paragraph. Remember I said before that you have the right to assign your interest with the seller's approval, but they can't be unreasonable in denying approval. Well, what if you want to assign your interest to the seller's neighbor and the seller doesn't like the neighbor? Well, that's a reasonable grounds to say no. Or what if you're assigning it to somebody and the assignee is paying the buyer a large sum of money for the assignment? You have to tell the seller how much you're getting paid for the assignment. And the seller could say, well, that's too much money. I'm not going to agree to that. This also explains that buyer, if you want to assign your interest to your own trust or your own wholly owned entity, you can do it and you don't need the seller's permission. And also remember, you have a deadline now to request this. I'm almost done. Here's maybe the most important change in the contract: the definition of deliver. As you know, when you're in escrow, both sides are constantly delivering things back and forth. If I'm a buyer, I submit an offer. The seller delivers an acceptance or a counteroffer, or I give you an addendum, or I give you a notice to perform, or I give you a disclosure form, or I give you a request for repair or a cancellation. You constantly are sending documents back and forth. And of course, the listing agent sends a document to the buyer's agent. Buyer's agent sends it to the listing agent. You don't have to send it directly to the client. You send it to their agent. And you have a deadline to do all these things. And if you miss your deadline, you can get canceled. Okay, that's fine. But what does it actually mean to deliver something? So if I'm an agent and I need to deliver to the other side an acceptance or a contingency removal, whatever, what does deliver mean? Well, let's look at the definition here. Deliver means it's effective upon personal receipt by the other side. Great. So if I deliver to you, it's considered delivered once you receive it. What does it mean to receive it? Well, it starts off with the old definition. Personal receipt means a copy is in the possession of the other side. So if I send you an email, when is an email in your possession? When it hit your inbox or when you opened it? That's never really been clear. So for 30 years, I've been telling realtors, when you send an email, you deliver something by email to the other side, get them to respond and acknowledge that they received it. Otherwise, they could always say, you said you sent it by email? I didn't get the email. Must have gone to spam. Or, yeah, I got the email, but I never opened it, which means I didn't get it yet. Look at the new thing here. The definition of delivery now also means an electronic copy has been sent to the designated electronic delivery address specified in the broker section. So here's the big change. At the end of the form, sorry about that. At the end of the form, there's always the broker box, right? There's the box where you guys sign. But before I get there, by the way, we got rid of, you don't need the representative capacity signature disclosure form. It used to be, right, if you were signing on behalf of the buyer who's an entity or the seller's an entity, you had to attach the RCSD form. You don't need that anymore. I mean, if the buyer's a thing, you just check the box. And in paragraph B3, you put the name of the person who's signing, the legally authorized signer. And remember, that person has 3 days to send written proof to the other side that they're the right person. But no longer do you need the RCSD. You're actually only going to use that form if you're assigning your interest to an entity. then that entity is going to fill out that form. But anyway, so on the last page of the form, you're familiar with this. You're used to it. You always have to put your broker's name, broker's license number, your name. If you got a partner, two of you can put both of your license numbers there. But now look at this. Buyer's agent, when you write your offer, you're supposed to put in your designated email address. And the listing agent, the same thing. Who's your broker? What's your DRE number? And what is your designated email address? So if I'm the buyer's agent and I give you my email, I'm saying to you, if you want to send me something, if you want to accept this offer, you want to send me a disclosure form, you want to send me a termite report, you want to send me a notice to perform, you have to email it here. But if you email it to this address, as soon as you press send, it's considered delivered. See what I'm saying? In other words, you don't have to prove that I opened the email. You just have to prove that you sent it. If you sent it, it's considered delivered. Which means, remember how there used to be in this last paragraph, there was a box there, acknowledgement of receipt? Because the buyer would send in the offer, the seller would sign it, you'd send it back to the buyer, but you want to know that the buyer's agent received it. So you know you actually have a contract. So the buyer's agent would check, would say when they received it. But that's not necessary anymore. If you're the listing agent and you send it to the email address the buyer's agent gave you, it's considered delivered. You have a deal at that moment. Which means everybody has to keep track of their emails and check their emails, because once it hits their email, once it's been sent, it's done. What if it went to spam? That's your fault on the recipient side. You need to make sure the other agent isn't blocked by spam, isn't diverted to spam when they send you stuff. Hopefully this will all work out. I got to go, so I'm going to go through the questions real quick. Okay, Anita. In RPA removal of all contingencies, does buyers still need, can the buyers still need contingency removal and have right to cancel? Good question. If you remove your contingencies as a buyer in your offer by attaching a contingency removal, you still have a right to cancel based on the TDS, the SPQ, the lead paint, the NHD, and the fire hardening defensible space. You still have 5 days. No, the HOA docs does not give you a right of rescission. Once you remove the contingency, you can't complain about the HOA docs. But even if you remove all your contingencies in your offer, once you receive the big 5 disclosures I talked about, the big 6 now, those do trigger a 5-day right of rescission. Sharon Jenkins, 3 and 5. I don't know what you mean by 3 and 5. What paragraph you're referring to. Maybe you can email me later, okay? Yeah, the bottom line answer to the question is, what proof do I have to provide? You have to provide the part of the trust document that says this person is the trustee. Donna, yeah, I sort of use those terms interchangeably. Manufactured home is probably the more correct term than a mobile home. Betty, the appraisal contingency, my offer is contingent on the property appraising at the purchase price. Meaning, that's pretty clear. But what I didn't mention, which is, I'm glad you raised that back in paragraph 3, is that you can now, when you write an offer, did you know you can actually say the appraisal contingency is not based on the purchase price? You can say, my offer is contingent on the property appraising, sorry, at a different number. So I can say, remember that's one of your 8 contingencies? Appraisal contingency based on the appraised value at a minimum of the purchase price or something else. So you could put a number here like 10,000 less than the appraisal price or more than the appraised price. So if that's what you're asking me, you can do it a little bit differently now. Because some people want to say, yeah, my offer is contingent on the property appraising or up to less than 10. In other words, I'm assuring the seller, even if it doesn't appraise at the purchase price, I'll still buy it if it's only like 10,000 less. I'll make up the difference, in other words. Okay, I think that's what you're getting at. Back to the chat. And I'm sorry, I do got to leave in a sec, so sorry I'm rushing here.
There's also, I'm not certain if you saw the Q&A question.
Yeah, I'll do that.
Okay.
Yeah, I'll do that too. Ed, good point. Does that mean all deadlines are passive? No, because if someone misses a deadline, you still got to give them a notice to perform, right? So it's not like the deadline means what it says, but just because someone meets a deadline, that doesn't give you the right to cancel, and you still give them one more chance. Same thing with contingencies, right? Contingencies aren't removed automatically, but if you don't remove it when you're supposed to, the seller can give you a warning. And then if 2 days later they don't do it, you can cancel them. So that's a good point, actually. Contingencies are definitely passive. Contingencies automatically, are not passive. The deadline to remove a contingency automatically is extended. But Ed, good point. The other deadlines in the contract are not automatically extended, but you have to still give a notice before you can cancel based on that. Melody, what's the document needed for us to collect to show who's the trustee? It's just the trust document itself, not the whole thing, the portion that talks about the trustee. Donna, how would the buyer's agent know the designated seller's email? Because the listing agent's going to fill in the box on the last page of the contract, right? Cheryl, good comment. Gail, if you want to, you can designate a text number. If you're okay with the other side sending you documents by text, and that's considered delivery, fill in the text number. If you don't want that, then don't fill that in. Great question, Sharon. When you get to the last page, the escrow holder acknowledgement, escrow holder is advised by. The idea is you're supposed to give the purchase contract to the escrow company. And on the purchase contract, you're supposed to, at the end, fill in the escrow box and say, this is the date of acceptance, right? So you're supposed to fill that in. Don, I see your point now. Listing agent doesn't have the offer yet, so they haven't put in their designated email. You're right. When you're actually sending the original offer, you're going to have to figure out on your own where to send that to. Hopefully you're talking to the listing agent and they will tell you where to send it. But you're actually right. You don't have a designated email as the buyer's agent because you haven't filled out the form yet. Okay. Unfortunately, guys, I have another meeting, so I'm just going to look at the Q&A real quick. Sorry, I didn't time myself right today. Carla, in the Q&A, will the landlord receive help if the tenant claimed COVID impact but refused to apply for rental assistance? No, but you can apply. If the tenant doesn't cooperate, you can now just sue the tenant. But no, you're not going to get rental assistance if the tenant doesn't cooperate. Gail, remember I already talked about this, the NHD. You're not going to be able to rely on the NHD form in its current format once CAL FIRE maps out these local fire responsibility areas, but we're going to get that fixed before those new maps are out there, okay? Teresa, page 16, designated email doesn't auto-populate. Right, you have to fill it in yourself. Jamie, if signing acceptance is trust, must you pull in the full trust information? That's a good question. If the seller is a trust or the buyer is a trust, technically, the party is being bought by the trustee on behalf of the trust. So believe it or not, you don't actually have to put in the full trust information. That's optional. What you have to put in is the name of the trustee, and then you have to send to the other side the portion of the trust document that says this person is signing on behalf. And that's going to tell you what the full name of the trust is, the trust document, okay? Because otherwise, I mean, I would always recommend putting the full trust name in there on page 16 on the signature page, but it's not actually required. Sewer lateral, Sandy, good question. And then I have one last question after that. Question is, you know, the normal rule is when you have an inspection, the home inspector can't do the work called out by the inspection for 12 months. There's now an exception to that for sewer lateral. So if the inspection, your home inspection is done by a contractor who has the license to do the sewer lateral inspection, and they call out on the home inspection problems on the sewer lateral, that same person can do the sewer lateral repair work, but only the sewer lateral work. Last question, SB9. Can HOA boards prohibit ADUs? So in other words, remember, SB9 is not ADUs. HOAs can prevent new buildings built under SB9. HOAs cannot prevent ADUs like the garage conversion, okay? These are all great questions. I sort of went too long, not that you're not willing to stay, but I have to go. So Lisa, I gotta go.
Thank you, Gov, so much for your time. It's really appreciated. Thank you, everybody, for tuning in. Again, your wealth of knowledge. Appreciate your time. And everybody have a good day. Again, this will be available by recording, but it will be a few weeks before it's available. Thank you, guys.